Thank you, Salvia. Oh, it's a privilege of a speaker to be able to take off the mask. Thank you for having invited me to speak at this conference devoted to the issues of selection, evaluation, and promotion of judges. I'm very happy to see this project advance, not least because recent developments in many countries of Europe and the enriching jurisprudence of the Court of Human Rights and the Court of Justice give to it an additional impetus. The topic which I have been invited to address, appointment of judges seen through the lens of judicial independence, is directly linked with the selection, promotion, and evaluation of judges. The very essence of any system of selection and evaluation and promotion is not only to choose the right people for the right job, but also to create public trust and confidence in persons and in the procedure and in persons once appointed as judges. If, however, a perfect result of a selection can be circumvented by discretionary appointment mechanisms, one can ask ourselves, is there a point in refining to perfection the selection mechanisms? Or maybe alternatively, vice versa, the appointment mechanisms can compensate for the shortcomings in the selection system. I leave these questions open for the moment. And certainly, the system by which judges are appointed is one of the key factors by which judicial independence is measured. Judicial independence is a prerequisite to the rule of law and the fundamental guarantee for a fair trial. Judges are charged with the ultimate decisions over life, freedom, rights, duties, and property of people. Their independence is not a privilege which serves their own interests, but rather the interests of the rule of law and those seeking and expecting justice. In the context of the European Union law, independence is a key requirement for mutual trust, the bedrock upon which the EU justice policy should be built. Some 10 years ago, the topic of judicial independence seems almost exhausted in most countries of the European Union. Judicial independence appeared as an unchallengeable axiom after the great enlargement in 2004, when mostly 10 Eastern and Central European countries joined the Union. All of these countries had to meet the so-called Copenhagen criteria as a precondition of accession, which also require that European standards are applied in administration of justice. Although the judicial independence was quite often addressed in the jurisprudence of the European Court of Human Rights, systemic problems regarding this principle were not revealed, and it seemed that judicial independence is living its golden age with the unreversible reforms directed towards its strengthening and maybe some fine-tuning in the jurisprudence. Regrettably, the impression of again strengthened judicial independence has proven illusory, and the last decade has shown again how fragile judicial independence can be. It suffices to think about some developments in the European Union and elsewhere. When it comes to the European Union, the organization of the judiciary, its institutional aspects, and its functioning have been traditionally considered as belonging to the exclusive competence of the member states, falling within the notion of the so-called procedural autonomy. The foundation for the judicial response to systemic deficiencies in the functioning of the judiciaries was laid down by the Court of Justice in the so-called Portuguese judges case. I will not comment on the facts of this case, since I'm sure they are very well known to everyone. I'll just briefly mention that that case, which was initially instituted as a judicial review of austerity measures, was transformed into a case on the organization of the European judicial systems. More broadly, it shifted the focus from the economic crisis to the rule of law crisis and created an opportunity and a legal basis to assess some controversial judicial reforms in several European countries, and introduced a new aspect into the EU law, imposing an obligation on member states to ensure that all courts and tribunals that might potentially be called upon to apply the European Union law offered effective judicial protection. Secondly, the Court of Justice stated that Article 19 of the Treaty on the European Union contained an obligation to ensure judicial independence. This implies that Article 19 of the Treaty on the European Union is also applicable to situations that are not related to any substantive area of European Union law, as long as national courts may be called upon to decide on the interpretation or application of the European Union law, the so-called potential jurisdiction test. Thirdly, although the principle of mutual trust was only briefly mentioned in the judgment, it seems to have strengthened the court's reasoning, according to which only independent courts could be trusted with the loyal application of the European Union law by the Court of Justice, but also by other national courts. So the ruling added a European dimension to the concept of judicial independence and granted an additional remedy to national judges as part of European judiciary to protect their independence through preliminary ruling, a mechanism that is fiercely defended by the Court of Justice. The doctrine of judicial independence is constantly evolving. There is no exhaustive checklist that has been formulated either at national or European level, as mentioned by Georg before me. The Court of Justice deems an independent tribunal to be one of the requirements linked to the fundamental right to an effective remedy in the sense of Article 47 of the Charter. It includes into the list of guarantees of independence the rules as regards the composition of the judicial body, the appointment, length of service, grounds for abstention, rejection, and dismissal of its members, but also a certain level of remuneration which commensurate with the importance of the functions that judges carry out. Based on the jurisprudence of the Court of Human Rights, the Court of Justice recognized the autonomy of the member states in constructing the model of interaction of the judiciary with other branches of state power. Neither Article 6 nor any other provision of convention requires state to adopt a particular constitutional model which governs the relationship and interaction between various branches of state power. The states are not required to comply with any theoretical constitutional concept regarding the permissible limits of such interaction. Similarly to the European Court of Human Rights, which conducts a global analysis to determine whether in a given case the requirements of the convention have been met, the Court of Justice also puts emphasis on multiplicity of factors and the general context that risks undermining judicial independence. One or another factor may be such as to escape criticism and fall to the competence and the choices made by the member states. However, when taken together, in addition to the circumstances in which these choices were made, they may throw doubt on the independence of judges. And this aspect can be well illustrated by the case Land Hessen, where the German Verwaltungsgericht from Wiesbaden asked a question about its own independence. Can I be considered an independent court within the meaning of Article 267 of the Treaty on the Functioning of the European Union? And just to remind you that according to the settled case law of the court, the preliminary ruling mechanism can be activated only by a body responsible for applying EU law, which corresponds inter alia on the criteria of independence. Hence, independence of a court is a preliminary question for admissibility of a request. The doubts of the German court were based on the following circumstances. The judges are appointed and promoted by the Minister of Justice. The appraisal of judges is undertaken by the Ministry of Justice according to the same rules as applicable to the public officials. The personal data and professional contacts of judges are managed by the ministry, which thus has access to these data. The Minister of Justice prescribes the external and internal organization of the courts or tribunals. It manages staff, IT facility. It even decides on work-related travel abroad undertaken by judges. In addition, the majority of the members of Judicial Appointment Committee, which is in charge of selecting judges, are designated by the parliament. Well, we very well know in Lithuania that similar provisions of the Lithuanian law on courts were declared unconstitutional in 1999 by the Constitutional Court of Lithuania. The Court of Justice, however, rejected any doubts about the independence of German courts. It reiterated that the assessment of the independence of national courts must be made in the light of all relevant factors. The court stated that there are no indications as to the manner in which the executive uses its powers as to cast legitimate doubts whether the judge is independent. This later aspect relates to the circumstances in which certain legislative choices were made, the context. And we certainly must admit that the context of legislative choices in Germany, which is l'état de droit par excellence, is very different from the context of some legislative reforms in Poland, which pleaded counter the independence of the disciplinary chamber of the Supreme Court, as it was found in AK case. The criteria of the context was also used by the Court of Justice in the Maltese case, Republika, concerning alleged absence of judicial independence in Malta due to some discretion of the Prime Minister in appointing judges. The Court of Justice stated in principle that since 2004, when Malta joined the European Union, there were no reduction in guarantees of judicial independence. On the contrary, a new body, Judicial Appointments Committee, was established in 2016. Although the system is still not perfect and criticized by the Venice Commission, the context is of the strengthening and not of weakening judicial independence. I don't want to create a wrong impression that infringement of judicial independence will not be sanctioned by the Court of Justice as long as there has been no significant reduction in the guarantees of independence. This is not the test applied. But certainly the direction of the reforms is one of the factors to be taken into consideration in assessing the compliance with Article 19 of the treaty. Regarding the appointment of judges, the Court of Justice underlines the necessity of substantive conditions and detailed procedural rules governing the adoption of appointment decision. However, these requirements are not defined in a positive way. The Court of Justice does not give any substantive indications how these rules should look like. It states simply that these rules should exclude any reasonable doubt in the minds of individuals that the judges concerned remain independent from external factors. In addition, those conditions and detailed procedural rules shall be drafted in such a way as to preclude not only any direct influence in the form of instructions, but also the type of influence which are more indirect. The mere fact that judges shall be appointed by the executive does not give rise to a relationship of subordination if, once appointed, they are free from influence or pressure. If the appointment mechanism in a member state provides for the participation of a body empowered to ensure the independence of justice, such as Judicial Council, its participation may, in principle, be such as to contribute to making that process more objective. However, this is only the case if that body itself is sufficiently independent of legislature and executive. Finally, yet importantly, it seems that Court of Justice includes into the list of requirements of formation of an independent judiciary an effective judicial review concerning proposals for appointment to the post of judge, covering, at the very least, an examination of whether there was no ultra-virus or improper exercise of authority, error of law, or manifest error of assessment. In the light of these considerations, I will now briefly address some aspects of the appointment of judges in my home country, Lithuania. Well, the judiciary is the only branch of power formed on a professional rather than a political basis, as stated by the Constitutional Court. However, the process of the appointment of judges very frequently rests in the hands of political powers. It can become a complicated exercise, in particular when more than one political power is involved in judicial appointments. The jurisprudence of the Court of Justice and the Court of the Human Rights is clear on this point. The mere fact that judges are appointed by the executive does not give rise to a relationship of subordination. If once appointed, they are free from influence or pressure. What matters in essence is the transparency of the appointment process, accompanied by clear substantive conditions and detailed procedural rules combined with an effective judicial remedy. The constitution of Lithuania itself is silent on who selects candidates for judicial nominations. The selection of candidates for judicial vacancies has never been in the hands of the judiciary itself. The central role in the selection of future judges and their promotion lies with the executive, the President of the Republic. Unlike in many countries of the region, and I would say contrary to some recommendations also of Council of the European Judges, Venice Commission, the Judicial Council of Lithuania does not choose between candidates to fill in a judicial vacancy. This choice is made by the President of the Republic. First, although the Commission for Selection of Judges submits to the President of the Republic a priority list of all candidates having applied for a vacancy, followed by its recommendation on most suitable candidate, the choice from all these candidates is made by the President of the Republic. In practice and in accordance with the jurisprudence of the Constitutional Court, the President of the Republic makes a take it or leave it proposal of only one candidate to one judicial vacancy. That leaves quite a limited say to the Judicial Council in the process of the formation of the Corps of Judges. It amounts to a veto right of the Judicial Council against the candidate chosen by the President of the Republic. Second, despite the selection procedure, which is based on objective and predetermined criteria, the President of the Republic is not bound by its results, nor by priorities established by the Commission for Selection of Judges, which have only a recommendatory character. In contrast, the President of the Republic enjoys discretion in his or her choices. As emerges from the interpretation by the Constitutional Court, the Constitution does not imply a possibility for the establishment of any such legal regulation whereby the person who has been included in the list of candidates to become judges would somehow be rated or have their priority determined in a way which would be binding on the President of the Republic. Although in practice the recommendations of the Commission for Selection of Judges are usually followed, on rare occasions the President of the Republic chooses a candidate who is not among top ranked by the Commission. The jurisprudence of the Constitutional Court does not require from the President to give reasons for his choice. In addition, no official reasons for non-selection are provided to non-accepted high-ranked candidates. In practice, the representative of the President gives a presentation of a proposed candidate during the meeting of the Judicial Council. We can ask ourselves whether this presentation could be considered reasons, since reasons should not only pertain to the fact that the proposed candidate is a good one, I have no doubts about it, but more to the justification why the proposed candidate was better than the other candidates and why the higher ranked candidates haven't been retained. Moreover, for the sake of transparency, these motives should be made public in the same way as the motives of the decision of the Commission for Selection of Judges. If we look, for example, at the judgment which I've just mentioned, Republika, the Maltese case, where the Court of Justice responded to the doubts raised about the independence of judges in Malta due to some discretion of the Prime Minister to depart from the selection of the Judicial Appointment Committee, the Court of Justice rejected these doubts, using, among others, the argument that the Constitution required from the Prime Minister in such a situation to communicate his or her reasons to the House of Representatives, the Parliament, and to publish them in the official gazette. Why the head of state would motivate his or her choice if, unlike in Malta, he or she is not required by the Constitution to give motives? The answer is very simple. That would be in line with the principle of good administration, contribute to a more complete system of transparency, strengthen judicial independence, and increase public trust in judiciary. And certainly the necessity to provide reasons, tests, and constraints the decision taker himself or herself, because only by motivating we can ascertain ourselves whether our decision is correct. Third, unlike the President of the Republic who makes a choice from multiple candidates, the Judicial Council is obliged to give reasons for its decision, even if it's faced with a simple take it or leave it type of request from the President of the Republic. Fourth, there is no judicial or other legal remedy against the executive in the sphere of judicial appointments. Certainly, the latest legislative amendments from 2019, which implemented the recommendation of Greco from 2014, according to which the Judicial Council should be given a more important role in the procedure for selecting judges, are a step into the right direction. But I think this is only one step. These amendments have not finished the process, which is also constantly enriched by the jurisprudence of the European courts. I come to a certain conclusion that the center of gravity in the process of appointment of judges in Lithuania lies within the executive. We might ask ourselves if the discretion of the President of the Republic is sufficiently counterbalanced by the restricted role of the Judicial Council in this constitutional process. I'm not casting any doubts on the compliance of Lithuanian judiciary with Article 19 of the Treaty on the EU. The compliance with Article 19, however, does not prevent from aiming at higher standards of judicial independence, as it was done, for instance, in Malta, which, despite the positive Court of Justice judgment in the Republika, amended its constitution and introduced a new procedure for appointment of judges that does not involve governmental discretion. I think that further discussion could be useful on these points. I think that the project within the framework of which we are gathering today could also serve as a start or basis for this discussion. I thank the organizers for having invited me, and I wish you all a very fruitful discussion. Thank you very much.